Law Talk with BJ, the podcast where trial attorney and legal commentator BJ Bernstein and her guests discuss the latest issues from around the legal world. BJ is a frequent commentator on television and radio. She's unique in that she not only comments on legal issues, having been lead counsel on numerous high-profile cases of national interest, but her relatable personal style allows the viewer to understand the law behind the headlines and why it's important. Now, here's your host, BJ Bernstein.
Welcome to Law Talk with BJ. This is our first guest of 2019, and I'm looking forward to this conversation because he is someone who has a job that you would not think would have so much law in it, but between his background and the reality of college campuses today, law is an integral part of his job. And who that is Lawrence Shaw, president of Oglethorpe University. Welcome.
Good morning. Happy 2019. Hard to believe.
It's here. We met in 2018, and someone was telling me about him, and then I followed up and did a little reading. I said, I'm going to call him and invite him to the podcast. And I think you're going to understand why. When you think about what's going on at college campuses and what presidents of universities have to deal with, Lawrence had been an attorney for a number of years before going into academia, and during his time as a lawyer was a civil rights attorney. And of course, those civil rights issues in the form of Title IX are a certain very hot spot that we'll talk about a little bit in terms of what's happening on college campuses. And he's also stepped into the role of leadership over the years after Sandy Hook, becoming the leader of the college presidents for gun safety.
Correct. And
most interestingly, on the side, was it in 2015, did a moonlighted as an Uber driver?
I did. You wouldn't think that's the thing I'm most known for, but my wife and I use Uber all the time, and I sort of got intrigued by the sort of business model, and everybody talks about higher education being disrupted, and so I sort of thought, what better way to understand the whole disruption of the transportation industry than to sign up and be an Uber driver. So I drove for a handful of hours in the summer and made almost $200
and wrote the piece for the Washington Post.
And wrote a piece for the Washington Post and ended up on some TV somewhere.
But I think it's interesting, and I think it ties into all the reasons that intrigue me about your career and talking about law, is that you are the type of person apparently who you see something and you want to have insight into the impact of the people who are affected by it. And obviously the Uber economy and who that is for was something that caught your attention. And I would imagine the same thing happens to the students at your university, that you see them at their younger years and you're wanting to shape them and understand what is happening for their benefit and understand the background of it.
Yeah, it's sort of how I ended up deciding to end my legal career, because I think I'm by nature more of a doer than a sort of thinker. And I worked for 3 years on one case that went up to the Supreme Court a couple times, and spent basically 3 years on the law library. And at the end of that, I was like, I cannot do this anymore. I love being in court. My practice was almost all federal court practice. I loved when I was in court. Got to argue in front of the Third Circuit a handful of times before the age of 30, but spent most of my time writing briefs and thought, I can't keep doing this. So that's...
You don't get the interpersonal contact that you do you do now.
Exactly.
And so your civil rights work, what type of civil rights work originally were you working on?
So I worked for two firms. Well, I was a legal service lawyer in Philly. Did a lot of housing work, public assistance work, Medicaid work. In the last 3 years, I worked for a small private law firm called the Juvenile Law Center. So I represented, the case I worked on was the kids being held in jail pre-trial. The juveniles didn't have a right to bail, so they would, spend 3 months, 6 months, 12 months in jail. And so we brought a case sort of challenging the right of the state to hold juveniles without standards in prison. And It's Coleman v. Stanziani, and ended up sort of being the landmark case that created sort of national standards.
And when was that approximately?
So that was 80, I got out of law school in 78, and I practiced till 85, so this was the tail end, sort of the early 1980s.
Just in terms of jurisprudence and looking at things, that's a really, we should have been at a cultural level not till the 1980s of deciding that juveniles should be able to make bond after being accused in offense, while an adult could make bond in 5 minutes by calling the bondsman and have bond being set.
Right. Well, the whole idea was that the state was sort of acting in the best interest of children and holding them and reforming them when in fact they were just being sort of housed in juvenile jails. So yeah, it's come a little bit of ways, but
we still have a long way to go.
Still have a long way to go.
And now, obviously, the talk in terms of college campuses is the changes with regard to Title IX, the federal civil rights law that deals with education. First, we throw around the term Title IX a lot.
Right.
I think from everything from we hear it on the news to there's a women's clothing for sports called Title IX Sports. But I don't think most people know what Title IX is, what it really is supposed to do. So let's start there, with the basics.
So, yeah, I think everyone's sort of first touch with Title IX was around gender equity in sports. So if you were, and that still applies. So we have 8 men's intercollegiate teams at Oglethorpe, and we have 8 women teams at Oglethorpe. And so there are, this had to do with sort of equal access to opportunities at higher education institutions around sports. But in more recent history, particularly under the 8 years of the Obama administration, it was interpreted to include the denial of equal access to education based on sexual assault and sexual harassment, that those acts could, in fact, deny a woman equal access to academic programs. And so now when you think about Title IX, it's got mostly to do with sexual misbehavior versus athletic equity.
And there have been a lot of changes that more recently under the current administration, and you're seeing the results of that. I mean, the changes are relatively new. Are you seeing? Let's talk about what some of those changes are that affect the students in college.
Okay, so I think it's first important to sort of to understand that it's been over the last 8-10 years, there have been constant changes with regard to the requirements on higher education institutions. So it's not like when the Obama administration came in, they introduced a set of firm guidelines, and we've been working with those guidelines for the last 8-10 years. Those guidelines sort of came in slowly over time. They got interpreted, they got reinterpreted. So it's been a moving target. Generally, under the Obama administration, it was a sort of pretty clear direction. But how those rules and regulations got implemented did shift over time. And now, with Betsy DeVos leading the department, she had promised that they would promulgate a new set of proposed regulations about how Title IX was implemented. I think one of the interesting things to understand is that the proposed rules coming out under the Department of Education now, the DeVos rules, don't change the fact that Title IX applies here. So the basic principle that sexual assault and sexual harassment are activities that call into play Title IX has not changed. It's more how it's gotten implemented. And so they've set out a set of proposed changes. Their comments are coming in. We have not changed at Oglethorpe. We've not changed how we deal with this in response to these changes, but we will at some point have to when the sort of
when the dust settles and people start to figure out what this all means and the impact.
Yeah, and when the proposed rules become requirements. So there's a handful of them. Some I think more significant than others. There are a couple where they're actually giving universities more flexibility in terms of how they apply these rules. So the sort of standard of proof, the burden of proof is one of them. Under the Obama administration, we were required to use a preponderance of evidence standard as opposed to a clear and convincing standard. And now under the new proposed rules, the university will have a choice about whether you want to apply the preponderance of evidence standard, which is a weaker standard than the clear and convincing standard. Based on my conversations with colleagues at most universities, I've seen very few that are going to change. So we've used a preponderance of evidence standard. We think that works. We don't see a reason to move to a different standard, but we're being given the flexibility to move to a different standard if we choose to.
And what's the thought behind moving to a different standard? Why are they giving that choice?
Right. So I think the whole approach under DeVos is that they are working hard to, what they would say is to protect the rights of the accused as well as to protect the rights of the victim. And so it's their sense that there are generally men, it's been not always men, but generally men who have been accused and found responsible for acts for which they should not have been. And so one of the thoughts is that if there was a higher standard of proof, that then these men would not have been found responsible. I think in my experience in the cases I've seen over 14 years at Oglethorpe, very rarely has it come down to a standard of proof question. So
more on just believability, or just like in any criminal case where you hear the facts, you hear the circumstances around it, and the determination
you make a judgment.
is made.
You make a judgment as to And so in the cases I've seen, it changing the standard of proof would not have changed the outcome. But that's the rationale behind giving colleges the choice is to provide more protection to the accused. So that's one. They've also, it's interesting, they've given. So we see these sexual assault cases, sometimes could happen in a residence hall, but they could also sometimes happen in an off-campus apartment between two students. And so the new regulations giving the institution the ability to say that if it happens off campus at a non-institution sponsored event, that the school can choose not to investigate.
So, for instance, after a football game, a couple students go to somebody's house, then there's an assault is alleged, but there's no nexus to any fraternity or any organization sponsoring a party there. They're just saying let the criminal justice system handle it.
So they're saying that the college university does not have a responsibility to investigate that under Title IX. It would be referred to the authorities, but they're not requiring the university to not investigate. So
again it's a choice.
They're giving schools a choice. They're saying you're not required to investigate if it happens off campus. Again, I would doubt that many universities would choose to take up that choice, because if you have two students who are in class together, who are eating the dining hall together, who are in social circles together, and there's an assault, and whether it happens in a dorm room or whether it happens in a private apartment, you've got to deal with the consequences of that behavior. So, again, I would be very surprised that institutions would sort of say, well, no, those are our students, but we're not going to worry about it because it happened in an apartment. So that's another, again, instance I'm not quite sure. I think the rationale there is that if it happens off campus, it's should be dealt with by the law enforcement authorities. But if there are two students who are attending your university, you've got to deal with the consequences of the behavior, whether it happens in a dorm room. Doesn't really matter where it happened. One of the biggest differences is that they are changing the definition of sexual harassment. So they haven't touched the definition of sexual assault, but they are changing the definition of sexual harassment. And under the past 8 years, it's been unwelcome conduct of a sexual nature. If we find that there's been unwelcome conduct of a sexual nature, you can have a finding of sexual harassment. They're changing it now to conduct that's so severe, pervasive, and objectively offensive that it denies access to an educational program. It's a much higher standard. That will matter. I mean, that definition changes, that will matter. I would say almost all the cases that come up through our system are sexual assault cases. And sexual harassment is usually part of the sort of sexual harassment leads to the sexual assault.
Right.
But in the cases that we've seen, there's almost always an allegation of sexual assault and inappropriate sexual touching or rape. So the change of definition wouldn't affect that, but there obviously there are going to be lots of cases in various systems where the shift of the definition will mean that there's not a finding of responsibility on sexual harassment, and that's a significant shift.
And that's where the controversy really has focused.
So yeah, that's been one of the big places where there's lots of conversation. And the other major one has to do with the sort of due process and how hearings happen. So on some campuses, we're required to have a Title IX coordinator, investigator.
Right. I've dealt with one of those before.
Right. In some cases, that investigator is also the person that would make a finding of guilt. And they're now saying you can't have the investigator also be the fact finder. We've at Oglethorpe, we've never had the investigator be the fact finder. There's an investigator, and then we have a hearing, and there's a panel, and what happens in that hearing is that the students come in. They can come in with a counselor, but an advisor of their own choice. Person is not there to speak or to ask questions, but is a support person. They've now said that people can come in with counsel, and counsel have the right to cross-examine the other party.
Now, when that's happening, is the school providing counsel, or is counsel provided for the alleged?
I mean, currently
victim?
Currently, we don't provide counsel if the victim or the accused wants to get counsel, and they do on occasion. They can, but the counsel doesn't have a active role.
Correct.
And so, under the new changes, that the either party is allowed to bring counsel in the room, and the counsel can cross-examine either the accused or the alleged perpetrator. And this is a big change because one of the things that we're now put in the position of sort of acting like a court.
A court.
In some ways.
And I can say, in dealing with this, I've been a prosecutor, I've been a criminal defense attorney, I've been I sue people, and so I've been on different parts of all of this. And it is, as a lawyer, somewhat frustrating where, I would just be sending someone in who has no legal background on a decision that is deciding a lot. I mean, it may not be incarceration, but potentially losing your ability to get your education, which is the key to future career and everything else. It's a very huge thing to say you can no longer, pursue that without an attorney or whatever. At the same time, when I've represented victims of sexual assault, I know how hard it is for them to tell their story, to go through things, emotional trauma, and the concern of being traumatized by a lawyer's cross-examination. And then add that other piece of law enforcement that I don't think they've voiced anything, but I know from over the years, having been the prosecutor, sometimes saying, wow, the school got ahead of my prosecution and allowed some things to happen with their inexperience and knowledge in the area that has hurt the case from either side. So it's a very tricky, and I realize it's explosive. You want to say on the one hand, I support women, but also, there are accusations that are real, there are accusations that may not be, or may not justify expulsion.
Right. So yeah, these are very complicated, messy cases. The cases that we've seen, these generally are students who know each other, some relationship. It's not a stranger grabbing somebody and, from behind a dark corner. So there's generally some relationship that exists between the students.
Generally not 100%, because every now and then I've seen them otherwise, where, that you're at a party and you don't know who's really there and someone takes advantage and assaults you.
Generally, alcohol's involved.
Alcohol and drugs.
Not always, but generally. Sometimes they're witnesses, sometimes there's not witnesses to events earlier in the evening, not necessarily witnesses at the conclusion, but there are corroborating witnesses. And so college and universities we're really good at one thing, which is educating students, but we don't, we would not claim that, that our job is to adjudicate. I mean, that's, we do it when we have to. If there's an accusation of plagiarism, we have to adjudicate that. And now if there's accusations of sexual misbehavior, we're required to adjudicate that. And this is the changes are pushing this adjudicatory process into something that more parallels a judicial process. And, I think to the extent that it gets pushed into that direction, we become even less competent to deal with them because there's no judge in the room. So now you've got opposing counsel. Potentially you have opposing counsel in the room asking questions. I suppose one of the counselors could object to a particular question.
Who's going to make the decision?
Who's ruling on the objection?
Right.
You could have attorneys, behave inappropriately in terms of questions. There's the rape shield laws still apply here, but who is the person that's going to enforce the appropriate behavior by attorneys? So I don't,
it's a mess.
But these hearings have significant consequences for both parties. So yes, you often talk about the consequence of a young man being suspended or expelled from school because he's been found responsible. But I've seen the consequences to a young woman who's not believed or not treated well. So there are massive consequences on.
And that we could do a whole nother podcast about fraternities and those types of cases, and those I've worked on. Where there's so much alcohol, there are drugs, there's so many things going on, that it's quite frightening. To think the consequences that could happen in the assaults that in fact occur.
I think one of the most positive, unequivocally positive things that has happened over the last decade is the education that we do, and that won't change. So we have students come in, spend 4 or 5 days with us. Freshmen come in, before school starts. And one of the most important, significant things that happens during that orientation week is education around Title IX and appropriate behavior and inappropriate behavior and the consequences. And that continues. It just doesn't happen just that week. That continues for their 4 years, whether they're in a fraternity or whether they're an athlete or whether they're a general student. There's constant education of both men and women around appropriate behavior and
what the law is, because ignorance of the law is no excuse. And at a certain point, even beyond the Title IX, but shifting into the criminal defense, criminal arena, it's very dangerous, and we don't do enough. So it's good to hear, because it certainly wasn't part of my orientation 30-something years ago.
Mine either. Right.
And it wasn't even discussed. I mean, it was just like this bewildering thing when you got on campus and you would hear about something happening to someone.
Right.
And you just kept thinking that could never happen to me, even though, you would go to a party and drink too much and not be in a good state of mind and potentially victimize. I'm going to shift it a little bit because I mentioned at the beginning that you created with some others the college presidents for gun safety. And there's been a lot of changes since then with regard to carrying guns on campus. Each state, certainly we're in Georgia, and it does allow that. Have you have you seen anything, or what kind of education around guns on campus? Since that's a reality now, right. What do you see?
Yeah, so it's as much a political issue as it is anything else. So in Georgia now, on public university campuses, not private university campuses, but on public university campuses, faculty and staff and students are allowed under certain circumstances to carry a gun. Now, they can't have it in a residence hall room. They can't take it into an athletic venue. So a lot of times they stays in the trunk of a car. At Oglethorpe, we're a private university. We ban weapons of all sorts on campus by anybody. And we generally think it creates a safer environment than having students and faculty and staff walking around with guns. And, you mix guns, you mix alcohol, you mix mental health issues. We I think as a business, as an industry, think it's not a great idea to have people walking around on campus with guns. One of the things, I've been president for 14 years now, and probably in my early years, I would not have thought of speaking out publicly around such a controversial issue such as guns and gun safety. But, it hit homes. I've got friends who are presidents at schools that have had shootings. I was up in Blacksburg, Virginia last week and spent some time in Virginia Tech's campus, and my first time there, and the overwhelming sense I had as I sort of drove around was the shooting was, and I don't know, that's a decade ago maybe. So there's a lot of shootings on college campuses, a lot of shootings in elementary schools, and it got to a point where a number of us presidents got together and said, for us to remain silent on this issue didn't feel right. So Elizabeth Quiche, who was the president of Agnes Scott, and I at the time started reaching out to some friends who were presidents, and people seemed interested. And then we put something online, and literally overnight we had, 500, 600 presidents sign on. And what was interesting about it, and we ended up going to Washington and speaking to people in the administration. We did a tour of Capitol Hill. Nothing happened at the time. Maybe, with Parkland, maybe you begin to see things happen. But one of the conversations to spark was, so, when do we speak out? When do we not speak out on what kinds of issues? It's been pretty rare for presidents as a group to speak out on things. This gun thing was a real exception. Many of us have spoken out on DACA because all of us have students who are dreamers and see the impact on them. So it's, in my view, is you don't give up your First Amendment right when you become a president. The people, I think, in my position, because we try to raise a lot of money for our university, and we're raising money from people with lots of different political views. So I think there was some sense that increasingly over time, as that's become a bigger part of our job, that we were running a risk by picking sides on issues. That's probably true, but again, I think it's more important than ever that people have a voice and use their voice. And so I've sort of fallen into that camp of using my voice more than others. And
so that's a perfect segue to end. We've been sipping a cup of tea, and all my listeners know I choose a tea that's appropriate for my guest. And in this one, we're having a green tea with one of the ingredients of lemon myrtle. And besides strengthening the immune system, and it's cold season, so it's a good idea to do that. But the real reason I selected it was it helps support a healthy emotional place. It has a nurturing quality to it. And it sounds like to me, in your job of your background of law and now working with your students and speaking out, using your voice, trying to decide what's best for them, is the type of nurturing that I think every parent would want for their students on campus. So thank you for coming to Law Talk.
We need, 2019, we need a lot of nurturing, I think.
I think so.
Thank you, BJ.
Thank you.
This podcast is not to be construed as legal advice. With any legal issue, you should reach out to a professional attorney that practices law in the state and area of law for which you need information or consultation. Law Talk with BJ does not establish an attorney-client relationship, which is only formed when you have hired an attorney and signed an engagement agreement or contract. It's Law Talk with BJ music theme written and produced by Atlanta Audible. This podcast copyright 2018, BJ Bernstein, Esquire.